In family law, a flawed marriage falls into one of three legal categories. We are looking at Section 3 of the CPQ module, void and voidable marriages and civil partnerships. A voidable marriage is a unique category, legally distinct from both void marriages and non-marriages in its origin and effect. A void marriage never legally existed, but a voidable marriage begins with a formally valid ceremony, like the one shown here. It creates a legally binding relationship that carries full weight until a court explicitly intervenes to annul it. This status is grounded in specific legislation. These key statutes on formation, primarily the Matrimonial Causes Act 1973 for marriages and the Civil Partnership Act 2004 for civil partnerships, establish the exact criteria required to challenge that validity. This creates the valid until annulled principle. Every legal right, obligation, and financial tie associated with marriage applies from the wedding day up to the precise moment a judge issues a nullity order. This is a sharp contrast to a non-marriage or non-qualifying ceremony. In those cases, the formalities are so defective, perhaps lacking a registrar or prior notice, that the event falls outside the scope of nullity entirely. There is no marriage to annul and no financial remedies available. To dismantle a voidable marriage, an applicant must navigate a dual-filter architecture. First, they must prove a specific defect under Section 12 of the Matrimonial Causes Act. Then, they must survive the absolute statutory bars set out in Section 13. We will now analyze how this architecture operates in practice, examining the specific clusters of Section 12 grounds, the case law thresholds required to prove them, and the strict statutory firewalls of Section 13. For practitioners, a voidable marriage is an otherwise valid legal entity under attack. Dismantling it requires a precise statutory scalpel rather than a broad assumption of invalidity. We begin breaking down the grounds for voidability with the consummation cluster. As listed here under the law of nullity, these fall under Section 12, subsection 1 of the Matrimonial Causes Act 1973. The first specific ground is the incapacity of either party to consummate the marriage. The legal threshold here is severe. The incapacity must be permanent and incurable. It is for the applicant to prove that this condition exists, whether it stems from a physical limitation or a psychological barrier. In cases involving psychological capacity, the court applies the test established in Sheffield City Council. The judge must determine whether the individual is mentally capable of understanding the duties and responsibilities that normally attach to marriage. Parallel to incapacity is the second ground, the willful refusal of the respondent to consummate the marriage under Section 12, subsection 1b. The 1947 case of Horton v. Horton established the benchmark for this. The refusal cannot be a temporary hesitation. It must be a settled, definite decision arrived at without just excuse. There is a strict jurisdictional limit to note here. Both incapacity and willful refusal to consummate are grounds exclusively available for heterosexual marriages. They do not apply to same-sex marriages or civil partnerships. This cluster is often a practitioner's priority. Cases based on non-consummation are explicitly exempt from the standard 3-year time limit restricting other voidability grounds. Moving down the statute, we shift to grounds involving a lack of valid consent. Section 12 dictates that consent fails if it is given under duress, by mistake, or by a person of unsound mind. The threshold for duress requires fear sufficiently grave to overbear the applicant's will. It must be severe enough to destroy true, voluntary consent. The benchmark for this is Hirani v. Hirani. In that case, parents threatened to turn their daughter out of her home unless she married a man of their choosing. The court ruled this constituted undue pressure that overbore her will, rendering the marriage voidable. When relying on a mistake to invalidate consent, the law is narrow. The mistake must relate strictly to the identity of the other party or the fundamental nature of the ceremony itself. Mehta v. Mehta illustrates this. The wife believed she was participating in a ceremony of conversion to the Hindu faith, not a wedding. Because she was mistaken as to the nature of the ceremony, the marriage was annulled. Conversely, a mistake regarding a person's attributes, such as their wealth or character, does not render a marriage voidable. Deception about status does not compromise the legal formation of the contract. There is also the distinct ground of mental disorder. This applies when an individual is capable of consenting to the marriage on paper, but suffers from a disorder that makes them unfit for the ordinary duties of married life. In consent cases, the court is not judging the quality of the marriage. It is strictly judging the legal integrity of the contract at the exact moment of its formation. The final cluster of Section 12 addresses concealed attributes. This includes cases where the respondent had a sexually transmitted infection, was pregnant by another person, or had an undisclosed acquired gender. The critical requirement here is the applicant's complete ignorance. If the applicant knew about the condition at the time of the ceremony and proceeded anyway, they cannot later claim the marriage is voidable. Proving a defect under Section 12 is only the first filter. The applicant must then confront Section 13 of the Matrimonial Causes Act, which outlines the absolute statutory bars to a nullity order. The most rigid of these is the time bar. For almost all grounds outside of non-consummation, the application for annulment must be filed within exactly 3 years of the date of the marriage. Next is the bar of approbation. The court will deny an order if the applicant knew they could have the marriage annulled, yet behaved in a way that led the respondent to reasonably believe they accepted the marriage despite the defect. Additionally, the knowledge bar applies directly to the concealed attributes we just covered. If you knew about the pregnancy by another or the undisclosed gender history at the altar, the statute bars you from seeking annulment later. Section 13 is designed to serve as a legal firewall. It protects the finality and stability of the marriage status against delayed challenges. As a secondary filter, these statutory bars have the power to neutralize even a clearly proven Section 12 ground, forcing the parties to pursue a standard divorce instead of an annulment. When an application successfully traces the path from a Section 12 defect through the Section 13 firewall, it results in a final nullity order. We must look at the exact effect of securing this decree. The primary effect is that the marriage is legally recognized as existing right up until the day the final nullity order is pronounced. Unlike a void marriage, it is not erased from the beginning. Because the relationship had legal standing, any children born to the parties remain legitimate under the Legitimacy Act 1976. The annulment does trigger shifts in other areas. For inheritance, any provision made for a former spouse in a pre-existing will automatically lapses upon the final order. Crucially, a nullity order establishes the jurisdictional basis for financial provision. Both parties retain the right to apply for financial remedies under the Matrimonial Causes Act, mirroring the process of a standard divorce. For the purposes of dividing capital, property, and ongoing maintenance, the court approaches the aftermath of a voidable marriage in much the same way it handles a dissolution. The practitioner's workflow is therefore highly systematic. Identify the Section 12 ground, verify that the facts meet the rigorous case law thresholds, and audit the timeline and client conduct for Section 13 bars. Mastering the mechanics of these two sections allows practitioners to define the boundary between a flawed contract and a legally binding union.